Good morning. Can I welcome everyone to the 10th meeting of the Justice Committee in 2014. Can I ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with broadcasting even when they're put to silent. No apologies have been received. Item 1, I'm inviting the committee to agree to consider our approach to further scrutiny of Stage 1 of the Courts Reform Scotland Bill under Item 4 in private. Is that agreed? Thank you. Item 2, Courts Reform. This is a Stage 1 evidence, second session. And we hear from two panels of witnesses, and the first panel will focus mainly, though not exclusively if you don't want to, but mainly on the provisions of the bill relating to sheriff specialisation. I welcome to the meeting Louise Johnson, National Worker, Legal Issues, Scottish Women's Aid; Paul Brown, Principal Solicitor and Chief Executive Legal Services Agency; Sally Swinney, Chair; and Karen Gibbons, Vice Chair of the Family Law Association. And of course I know you, Ms Swinney, as a local solicitor in Peebles. I'll just let them know that in case you think there's some kind of favouritism, but there won't be. Right, can I have questions from members, please? Margaret.
Could I ask the panel's view on honorary sheriffs? Abolition or retention?
And can I just say before we start that if you indicate to me that you wish to answer, just let me know and I'll call you, and your microphone will go on automatically. You don't have to press anything. Right, anybody want to tackle that one? Honorary sheriffs? Ms Swinney.
Honorary sheriffs, from a family law perspective, I don't think we would have any view on whether they should be retained or abolished. I know from a general practice they deal with warrants and they can deal with hearings, but from the Family Law Association's perspective, we would have no strong view one way or t'other.
There has been some concern about access to justice in rural areas, so that wouldn't be something that would concern you in terms of family law?
From my own experience in Peebles, I can say that I've never appeared before an honorary sheriff. It's usually always been a sheriff, and I expect the position to be that when summary sheriffs are introduced, that you will either appear before a summary sheriff or a sheriff.
Okay, thank you.
Ms Johnson.
Good morning. We didn't cover this in our response to the bill, but we did cover it in our response to the prior consultation, and we said we objected to the office, and purely because legally unqualified persons were able to sit as sheriffs, and we thought that that was not acceptable, that such persons could actually hear civil cases involving child welfare and domestic abuse. So from that point of view, we objected, and if it's a resource issue, then perhaps the provisions in the bill would go some way to address that.
Else has indicated they want to come in there. Margaret, anything else?
Can I ask, if there were to be specialisms, what you think the specialisms of the sheriffs should be? Especially not honorary sheriffs, just sheriffs now.
Ms Johnson.
Yes. We would like to see specialism for sheriffs, not summary sheriffs. Sheriffs in relation to domestic abuse in both civil and criminal. There already is a certain degree of specialism, as you know. There are various courts across Scotland that deal with either all procedural parts of summary criminal cases or certain parts of it, say for instance trial or sentencing. We would certainly like that to be retained. We would like that to be expanded in whatever form can best be achieved, given the tensions and burdens of the court on rural and urban areas. And we would like specialists in family law. Now, there has been some discussion back and forward as to whether civil and criminal business should be mixed or separate, but we think there would be merit in having sheriffs who could deal with the civil and criminal, or at least have some link between the two proceedings in relation to domestic abuse.
View whether you would like to see sheriffs specialising in, for example, domestic abuse and rape, which may help the conviction rates?
I know Justice in their submission mentioned specialist sheriffs. Certainly any specialisation that would go towards improving the situation for women, children, young people in relation to domestic abuse, sexual assault, stalking, etc., we would certainly support.
Mr Brown.
Effectively, the new structure will mean that sheriffs, full sheriffs, will be specialists anyway, because so much will probably be dealt with by summary sheriffs. So my main concern is the huge remit of summary sheriffs, and within that context, I would have thought there would need to be specialisation. I mean, I would agree that the more separation between civil and criminal there is, the better. I can see summary sheriffs being able to take on family, defended evictions and so forth, children's hearing referrals, but expecting them to do summary criminal as well would seem to me like a bridge too far. Our experience at Glasgow Sheriff Court is there's specialist sheriffs for AWI, adults with incapacity cases, and that seems to be a sensible way forward. So the conclusion of that is a degree of specialism is built in already, but that needs to be cashed out by looking at all the areas and providing for specialisms within particularly the summary sheriff category, because otherwise I would imagine they would be overwhelmed. I think there is a problem with the vocabulary used when discussing summary sheriffs, because the references to low-value cases and so forth, children, divorce and so forth, those aren't low-value cases, they're high-cost cases. I mean, I've no problem with saying that summary sheriffs could deal with them with that, providing they have the training, specialism and professional background. But as I said, the vocabulary distorts the view with which one looks at those new posts, and I think that needs to be changed.
Can I ask you, I'd ask you to focus on rural areas then, an issue raised by Margaret already. You know, it's all very well having specialism, say, in large urban courts. What about, how would that work in small rural courts?
Well, if I can answer that, I echo the gentleman's concerns about the wording used in the policy memorandum. And I'll give you an example. It says to relieve sheriffs of the burden of dealing with the more routine, low-value cases. And there's other examples of the descriptions of run-of-the-mill cases, less complex civil cases, less serious and lower-level summary crime, and low-value cases. And those sorts of descriptions are not appropriate when dealing with family law issues. The association would welcome wholeheartedly specialist sheriffs, but we would also ask that that same specialism was given to summary sheriffs, because in my own area, and I suspect a lot of rural areas, the provision of summary sheriffs may overtake the provision of a sheriff. We're not sure whether, for instance, in the borders, we are in fact going to have a sheriff, and whether those sheriffs will only be available in the urban courts. So if it was the case of having a non-specialised sheriff or a specialist summary sheriff, the association would plump every time to have family cases dealt with someone who has the specialisation, whether they're a summary sheriff or a full sheriff.
To the point you made initially, which I think is reflected in some other submissions then, to refer to the value isn't necessarily helpful in that it doesn't necessarily reflect the complexity of a case.
Well, contact disputes, in particular, can rip a family apart. It's a pivotal part of society to ensure that these families are helped. And sometimes parties just need to be given advice into what is in the best interest. Most parties think they are acting in the best interest of their children, when quite clearly they're not. And with specialist training in child development and domestic abuse, that could help tremendously in dealing with very complicated and emotive issues such as contact disputes. When you're talking about divorce cases, which are primarily arguments about the possibility of the division of assets, then that's when the category of low value. But even so, if you're talking about a case which involves a family who has £5,000 worth of assets, that's not necessarily of any less importance to that family in arguing a case which involves £5 million worth of assets.
Yes, I'll take Ms Gibbons first.
Yeah, part of the difficulty, I think, for us as family practitioners is that we don't know how cases are going to be allocated between the specialist sheriffs and the summary sheriffs. I think Lord Gill's review had sort of indicated that he had thought that some of the case, that litigants would have an element of choice about where they raised their actions, but that doesn't seem to have fallen through, to have happened in the bill, because we're seeing in the bill that sheriff principals are going to have the decision about where cases or what types of cases are going to be dealt with by sheriffs and are going to be dealt with by summary sheriffs. And I think that is quite problematic, because in order for us to give a view as to what we think about specialism and about what we think about summary sheriffs, because we don't know how it's going to work in practice, I can foresee problems with simply saying in the bill that the Sheriff Principal has to make a decision, because on a logistical, practical basis, it's simply not possible for a Sheriff Principal on an individual basis to look at every single writ that comes in. So I can only imagine that what is...
In fact, the association mentioned senior sheriffs rather than the Sheriff Principal, but a sheriff with a great deal of experience, but not the Sheriff Principal.
See, I had actually thought that the bill said that the responsibility for allocation between the work was to lie with the Sheriff Principal. And so, in practice, I'm not clear how that will work. I can only imagine that what will happen is that the Sheriff Principal will have to say, well, in order for us to deal with this effectively, what we're going to have to do is say all cases of a typical, or of a certain type, say residence in contact, will be dealt with by the summary sheriff, and all cases, in order that there is a delineation, and all cases, say financial provision, that will be dealt with by the specialist. So in that situation, we've got, I think, really quite the opposite of what the bill is meant to achieve. The bill is meant to achieve ensuring that cases are dealt with at the correct level. But in fact, if the Sheriff Principal is simply, through no choice of their own, simply has to say, well, we're going to deal with these child cases at a sort of summary sheriff level, and the kind of higher up cases, if you like, the matrimonial provision ones or the financial provision ones will be dealt with the specialist, then there is no consideration of these cases. It's just an automatic. So the bill is meant to achieve, I think, ensuring that cases will be dealt with in the right level, but in fact it's just going to be automatic, I think, if that makes sense.
Yes, it does.
So, and I think that is one of the main problems. I can foresee problems actually with giving litigants choice as well, because I don't think that would work either. In my view, I think the best way of dealing with this is simply to see family law as distinct and say, well, all of these cases matter, and to have a situation where, perhaps like they have at Edinburgh Sheriff Court, I believe they have it at Glasgow, but I don't have any experience of Glasgow Sheriff Court, but in Edinburgh what they have is a number of sheriffs who sit as family sheriffs. And some of them, I think, have a family background, though not all. And I can say it works quite well in Edinburgh Sheriff Court. So there's not this delineation between, sheriffs of a different level. They're all sheriffs, but they're told that they are the family sheriffs. So what happens is you raise your action, and it's pretty much allocated to, not right at the beginning, but perhaps just before a child welfare hearing, for example. It's allocated to a particular sheriff who is a family sheriff. And they sit in, there's probably 2 or 3 at the moment in Edinburgh. And they hear cases, they sit the alternate weeks. So there's always a family sheriff at Edinburgh. So whenever you raise your case, it'd be given to a particular sheriff who will keep it to its conclusion. And there's massive benefits for that, for all involved, for the solicitors, for the children involved, because it gives consistency of decisions. Solicitors can not guess what the outcome can be, but they can give advice based on what they think that particular sheriff would do. And you tend to see good quality decisions coming through because the sheriffs know what I can't say know what they're doing, they always know what they're doing, but they deal with that type of work day in, day out, and so they become specialists at it.
Because I used to be a family law practitioner a long time back,
Yeah.
and I appreciate where there's a dispute about contact residency of children and so on. These really do need, I think, specialist sheriffs who put their heart and soul into it and get involved and continue the case for a very long time with reports and so on. But there are some cases that come up that would be family law cases where it's just a couple in a dispute about money in the family dug or something, and you can't be saying that they should go. They can't be seen as a summary sheriff. Some of them really are ridiculous, and it's just bitterness on the part of the parties that takes them to court. So there is a reason there to sift out cases. So are you adhering to your point that all family law cases should go to sheriff and a specialist sheriff, or do you agree that there could be some that quite simply could be sifted out?
You're absolutely right that there are going to be cases of a certain level, if you like to see it like that, that don't necessarily need to be heard by a specialist. The problem is in finding those ones out, if you like. And so, and for me, reading through the bill and all the papers that go with it, really the main thing that speaks to me is the problem about allocation is how you decipher how cases are, who should properly be dealing with these. Okay, I think, if you were able to sit down and consider every single writ, you could say, well, that could properly be dealt with by a summary sheriff. But the problem is that's not practical, especially somewhere in the bigger courts. Because you might even find that, and I don't know if this would happen, but I wouldn't like it to happen, that if cases are brought in, you could see a Sheriff Clerk looking at a writ and say, well, this only deals with children, there's no money involved, therefore I think this can be dealt with by a summary sheriff. And then you've got a situation where somebody who's not legally qualified is making a decision about who hears a case. And I don't think that's right. So I think for me the difficulty is in finding a proper way to sift things through. And
okay. Can I let somebody else in, Margaret, just for a little bit?
Absolutely, but just to say that was 2 points there, was how you decide to specialism and the problems of choice. If there isn't a specialism, although choice is built into the bill, then there is no choice if there isn't a specialism to go to. Was that your other point?
So you could just
this choice that was built into the bill, whether you could go to a specialist sheriff or have it decided locally. Obviously, if there isn't a specialist sheriff nearby, or you haven't the means to travel, there is no choice.
Well, there's that, but there's a choice of, I think the problem sometimes is that people in rural areas, if there is a sheriff, we don't know where the specialist sheriffs are going to be sitting. So I think it's envisioned that they're going to be sitting at the kind of there's 16 points throughout Scotland that they will be sitting. And so if you've got somebody sitting or living in a rural area, then they're not going to be able to, well, they might be able to travel if they decide that they want to and they've got the funds to do that, or if they've got legal aid funding to do that. But in essence, there is no choice for them to travel to the specialist sheriff. And so, it's not really fair, and it's geography that's dictating that.
Yeah. Before I go, I'm going to take, please come in a minute, but I'm going to take, John, are you on specialisms as well? Yes, it is. So it's all on the same thing. John, I'll take you next. And do come in, yes.
Thank you. Morning, panel. A number of questions for Ms Johnson, if I may, please. Your evidence is highly critical of the proposal that's been discussed with the earlier questions there. You also say that the proposals will not achieve reduced system and time delays, improved user experience, or fair and equitable justice for women, children and young people experiencing domestic abuse. Can you expand on that a little bit, please, Ms Johnson?
Surely. All the discussion on the role of the summary sheriff today has been very clear that they are to hear the low value, less complex, run-of-the-mill civil and criminal cases. The majority of the remit seems to be criminal for a start. Now, we think, first of all, that there's going to be difficulty with that at the summary level, but more to the point, the deprioritisation of essentially domestic abuse, other cases involving children, is not going to facilitate access to justice. If you have people who are doing what are referred to as the lower value cases, that's going to depreciate, excuse me, the public and, more to the point, the litigant and the participants' view of those particular cases if they're given to a lower level. Given that there are already delays in criminal cases in the Sheriff Court, the Domestic Abuse Court in Glasgow, instead of being heard at 8 weeks, it was originally envisaged, cases are now running to, I think, 22, 26 weeks. So given the pressure on the summary sheriffs, we don't see how that's going to be alleviated. So therefore, our position is that, for all the reasons we've been setting out since the review way back in 2008-9, we are quite definite that sheriffs, specialist sheriffs, should hear cases involving domestic abuse and a lot of cases involving children. If there are then, once these cases go to sheriffs, specialist sheriffs, it's decided that these aren't all those particular cases, then there might be scope to review them elsewhere. But we think that the sheriffs should retain the jurisdiction for these cases, which would ensure efficiencies in case management.
Yes, Mr Brown, do you want to come in the same thing to start with? Yes.
I think there's a fundamental issue about the simple procedure, because in that procedure, the summary sheriff will have an inquisitorial role. I can't see how that can properly be exercised without a degree of specialism, and that will include, the simple procedure will include adjudication on fundamental human rights, particularly defendant eviction cases, possibly repossession cases as well, and mortgage arrears. If that inquisitorial role is to be pursued at all, the sheriff will have to have expertise. There's no question about that. If specialist sheriffs in that area are not to be appointed in rural areas, then there needs to be some form of joint training, so there's some degree of consistency in the operation of that jurisdiction. I mean, I've already mentioned this, but I think the language used is prejudicial. When somebody risks losing their house, that is not a low-value matter. It's a high-value matter going to the heart of the family's human rights.
I think we probably be accept round the committee that that's an unfortunate terminology in the memorandum.
Convener, may I possibly come in again about the issue of access to the specialist sheriffs? We had mentioned this in our response, and what we said was we would support the development of specialist sheriffs, but we have concerns, as voiced by my colleagues, about it being in a distant hub and how would this work in rural areas. And we said that given that court users already travel considerable distances, it wouldn't be unreasonable to expect specialist sheriffs to travel to local courts. Now, my memory may be failing me, but I'm sure there was a reference to this back in the original Gill review about access to sheriffs. I may be talking nonsense, but I'm convinced that was referred to. But why shouldn't there be more of an opportunity for sheriffs to go out and practice their specialism, as opposed to just having this centralised in areas where people can't get access to justice?
I think when we were looking at the review of courts and court closures and so on, it was we did put to various witnesses, and it was replied to us that, in fact, yes, in circumstances where it's in the interest of the parties, for instance, a child welfare case, sheriffs could travel and set up a court in a community hall, you know, wherever. It didn't have to be in a sheriff courthouse. I think there's opportunities there, as you say, for rural areas to have equality of justice with specialist sheriffs travelling to the place where the parties are rather than make them travel to the city. Yes.
See, for my own experience, that in the borders, for some considerable period of time, it was the sheriff from Edinburgh who visited and sat at Peeble Sheriff Court, and that worked extremely well. It was only the sheriff who was inconvenienced by the travel. And likewise,
I won't lead you there because you've got to go in front of them.
the sheriff who sits at Selkirk also travels to Duns and Jedburgh and deals with the court there. So in the borders, it is not a new facet that the sheriff travels. In fact, the sheriff readily accepts that it's better to inconvenience him with the travel than it is to have all the parties travel. And for us, it just seems incomprehensible that that cannot happen.
Lord?
I wonder, Ms Johnson, in the policy memorandum, there is actually specific mention of the island communities, and if I read to you what it says in relation to that, it's therefore envisaged that the sheriffs currently in post at those island courts will remain in place, as it seems doubtful there would be sufficient business to justify the appointment of a summary sheriff at those courts, at least in the short term. Now, I think the important term there is at least in the short term. Could you share with us what the likely experience of a woman who you are supporting with children who would need to access a sheriff rather than a summary sheriff would experience, excuse me, having to travel to the mainland, say from Shetland to Aberdeen or perhaps even Edinburgh? The challenges connected with that.
Sure. Well, part of the problem might be to find a solicitor that would represent them. We have had difficulties in the past. Say, for instance, it was on Skye where a woman was unable to find a solicitor to represent her on Skye and had to travel, I think it was to Lochaber or even further to get one. In terms of travelling from the island to the mainland, you're talking about ferry times, having to find perhaps childcare, loss of income, and then there's also, I would suggest, the knock-on effects of everyone else who has to support that particular court. Now, if you're asking about difficulties from going from the island to the mainland, that would also have a knock-on effect on support agencies, and I would suggest as well police and, say, social work and everybody else who's going to maybe have to travel to the mainland to support that. In relation to the islands, would it not be possible for the sheriffs to sit as specialists on particular days? We know that, I said, this can be achieved in rural areas, so is it not possible to do that in the islands as well? Clustering the cases. I mean, the degree of clustering already happens in, say, criminal cases involving domestic abuse, so you could cluster family domestic abuse on particular days, weeks, and have it done like that. Does that answer your question?
It does, and it may well have already been suggested to the Sheriff Principal, who may already be looking at it. Thank you.
Thank you.
Just one final point, if I may. It may therefore be suggested, Ms Johnson, that in relation to domestic violence issues, that there's a role for mediation. Now, you mentioned that in your response. Can you say why that would be
I don't think there's a role for mediation. Domestic abuse, first of all, is not a dispute. We have to be very clear on that. It's an exercise, a misuse of power and control where one of the parties is clearly in fear, coerced, threatened by the other. Mediation is predicated on a degree of willingness to actually engage, and it's really unfair and quite, I think, dangerous and irresponsible to expect someone who is trying to just survive on a daily basis and mediate their lives in a way to have to undergo a process where they have to discuss issues of safety to themselves and children in a setting where they are open to further abuse, they are open to coercion, be it tacit or overt. And there's been a lot of discussion about sort of sifting this out, but it can be very subtle. And if someone, a woman for instance, thinks that she is obliged to undergo mediation as a precursor to even get the case into court, or she has to undertake mediation because it will be regarded, it will go against her if she doesn't, then she will undertake that process, but with great reluctance and possibly, and definitely actually, to her detriment. So we do not think that there is a place for mediation in relation to domestic abuse, especially in cases involving child contact.
Okay, thank you very much.
I don't think sheriffs can compel mediation in any event.
They can, I think, refer. It's the degree of compulsion that people feel they're
I doubt whether
they're
a
under.
sheriff would refer in circumstances
It has happened.
defensive, have they?
It has.
Extraordinary, then.
And I can tell you, convener, the problem is that women have actually said we felt that we had to do it.
Right.
Otherwise, it would go against us. I said either by suggestion or
In domestic abuse cases,
yes.
specifically. I'm
Yes.
quite surprised at that, Ms Swinney.
Can I also suggest that in cases of domestic abuse, it's quite often the case that the contact is used as a means of continuing the control, and that's another reason why it should be specialist sheriffs who deal with particularly contact cases.
Definitely support that.
No, I remember that from years back. Elaine, sorry, John, you finished?
Thank you very much.
Elaine, then John, then Sandra, then Christian, then Brodie. So you know where you are in my list. Feel secure. Yes.
I was wanting to hear your views on the issue about pressure on the courts, and the fact there's a feeling that sort of civil business tends to be squeezed out because criminal business is prioritised, and whether or not you felt that there was a missed opportunity here to separate civil or criminal and criminal business, or whether in fact you think that there would have been downsides to that approach as well. So just really to get your view around that.
Ms Swinney.
The association would feel strongly that civil and criminal should be separated. And again, I'm sorry to keep talking about the borders, but it seems...
Makes such a change from the Highlands and Islands.
If we encounter a difficulty in the borders, we tend to deal with it locally. And I can say again, at Peebles Sheriff Court, there was a recognition that there was a real difficulty with civil business being squeezed by criminal business, and the decision was taken to separate the two, so that on one court hearing deals with civil business, and then the next court hearing deals purely with criminal, and it works extremely well.
Do you think that should be actually in the bill, or is it better to deal with that as
I think it would do no
related,
harm. Yeah, I think it should be, yes.
Yes, may I?
Yes, of course,
Yes.
yes.
I think, excuse me, in terms of criminal and civil business, as I said, we would like to see the development or the rolling out of the specialisation in criminal terms of domestic abuse courts in whatever way that's possible. Given we've already discussed court business in rural areas, it might not be possible to have a specialist domestic abuse sheriff sitting every day, like, say, Glasgow, for instance, but there should certainly be the possibility to hold cluster courts over weeks, etc. And that, I think, would in itself generate savings. When you have sheriffs who develop specialism so they understand what's before them, part of this is about the information that they receive. So as we begin to improve information, it comes from the police to the fiscal to the sheriffs will begin to develop, and through judicial training as well, a greater understanding of it, and they'll be able to deal with these cases in a more focused way, and also to prioritise, therefore giving time for other business or other disposals for other business to be dealt with appropriately.
Some of these domestic abuse cases or family cases will be of urgency. How do you see that being resolved with specialist sheriffs? Again, say particularly in rural areas, when you're looking at interdicts or exclusions or whatever.
Well, again, if you have urgent cases, could it be, again, that you programme it that a sheriff comes and deals with specifically urgent cases on a particular day or time? Or there's much discussion about use of technology, video conferencing, etc. Could urgent cases perhaps be done in that way? Or some of the procedural work be done in that way, which therefore takes the burden off parties having to travel, and so the urgent cases can be dealt with, and then the facts of the case be discussed before a specialist sheriff at the next available opportunity.
Yes, Ms. Sonia.
That needn't be an issue. If you have a really urgent case, for the initial steps of a case, it just needs the written simply needs to be taken to the court and warranted and then served. It is generally the case, again in the borders that, or Edinburgh, that you arrange, you ring the court and find out when the sheriff is available, and it is fitted into the timescale. And I don't see that that's going to be a change when the bill comes in.
Elaine, I've got John Pentland, please, and Sandra. John.
Thank you, Convener. We've heard much about specialisation. I'm just wondering if the panel, if there was any categories of case that you would like to see designated for specialisation, and what would be your reasoning behind that?
Yes, Ms Gibbons.
I think certainly you can expect us to say family sheriffs are a must. And in fact, it doesn't really matter whether they are summary sheriffs or sheriffs, as long as they are experienced and have knowledge of family cases. That's the most important thing. And there are a number of reasons for that. And the most important thing I would say is consistency. Quite often you raise a case, in years gone by at Edinburgh anyway, you could end up with any sheriff. And at different stages along the way in your case, be it options hearing, child welfare hearing, proof, you didn't know what sheriff you were going to get. And the inconsistency with that can have a bearing on a number of things. It's not always good for clients. Sometimes they feel that if they get a sheriff that we appear in front of who particularly listens to them, and they go away feeling quite positive about what's happened in court, only to come back a few weeks later, perhaps for a child welfare hearing with a different sheriff who perhaps has less interest in what's happening in their case. They feel that they're not listened to, and they're really, it can have quite a big bearing on what happens in the case. Quite often as well, having the same sheriff dealing with a case can help focus minds a lot. If you know a sheriff is not going to put up with certain types of behaviour, or not going to put up with a report about a business valuation, for example, not being produced, then the clients focus their mind and make sure it happens, and quite often that can lead to earlier settlement.
I think it's quite interesting that you mentioned a business valuation, because just to make clear that family cases can have really complex commercial issues involved in it. So while you're talking about a family law sheriff being specialist, it might also have to be very specialist in commercial matters.
Right, that's right. There's a wide variation of the issues that can come up in family law, and for that reason, we do need specialists. The other thing to think about is the time saved sometimes in using the same sheriff. Is that if you appear various different hearings along the way, time can be spent in regaling the court with sometimes years, particularly in child residence and contact cases, years of things that have gone on. And a sheriff isn't really going to want to hear about years of things that have gone on from two different people with two different views of what's happened in those years. So quite often you can't get what you want across. The clients are unhappy because you can't do that. But time is spent in going through the various issues, whereas if you have the same sheriff each time, you turn up, you don't have to go through the background because they know what's been said. And quite often as well, the sheriffs, depending on the sheriff and their own nature, they can be quite good at reading the situation. So much about family cases is not necessarily about what's said, it's what's not said, and that can be, especially in the kind of domestic abuse cases, it can be quite important for a sheriff who understands the dynamics of what's going on between the parties and why somebody might have behaved a certain way, for example, and that can be hugely helpful. Family sheriffs who deal with family cases on a regular basis as well, you sometimes find can be quite creative with the solutions that they come up with, especially surrounding things with contact. We have certainly one sheriff in Edinburgh who I'm thinking of a particularly difficult case that we had with a client who was travelling from abroad for each hearing that was happening, and this sheriff would, he would find time in his diary, because that was his case, if you like, to hear that case, at times that suited for that client to come over from this from abroad. And that helped hugely. The creativity, I think, is useful in thinking about how contact is going to work. Sometimes thinking about different places where contact with the children will be more comfortable, being creative. Even things like telephone contact, for example, really listening to what's important to the clients can be hugely important at how a case pans out.
I was going to say, because I think probably the committee appreciates the values of the specialists in family, domestic abuse, but Mr Brown, I'd like to hear more, because people wouldn't usually focus on your area and say that. So if you could maybe...
Well, we represent significant numbers of children in children's hearing referrals, and also we have a specialist team dealing with mental health matters. In both cases, it's often very important to tell people what to expect. Don't necessarily mean about the particular legal issues, but just the demeanour and approach that the court will take. So I would support the notion of specialist sheriffs in both those areas. I appreciate there will be difficulties in some areas where the number of cases are very low, but certainly in the bigger the sheriff courts, there would seem to me to be a clear justification for children's hearing referral matters and mental health matters going to specialist sheriffs, particularly in mental health matters, having an understanding of the medical issues. I don't mean the sheriff substituting their own knowledge, but simply understanding what a particular drug might be or a particular diagnosis might mean. I would have thought that was essential. I appreciate lots of generalist sheriffs already know that, but being able to assume that they do have an understanding is very useful.
May I possibly just comment to say that these are very important points my colleagues have made, and in designating or someone wanting to be a specialist sheriff, they have to want to do that. Have the interest in it, because there's no point designating someone as a specialist sheriff and they're not interested, or they think that the issue is trivial, and for instance, they have opposing views in relation to domestic abuse, treatment of mental health, etc. So that's the success of specialist sheriffs is predicated on, first of all, the interest of the sheriff in doing that, the commitment, but also the training that goes towards supporting the appointment of specialist sheriffs, so they have information and awareness of all the issues around family, domestic abuse, housing issues, mental health, because otherwise we're just going to be back at square one.
Thank you. I mean, I've got a feeling we're quite well exhausting this panel, but I'm going to, exhausting the questions, but if there's something new to ask, yes, no, I'm not saying you haven't, I'm just laying that out. John, have you finished? Have you finished there? Just
well, just one small question. Obviously, I mean, the whole justice system, you know, I'm sure you agree, is going under review just now. And we're just wondering if you have any thoughts that what's being proposed in the court reform may have an impact on, for example, the criminal justice bill. Is there any issues there?
Oh,
it's probably directed at you, Lise.
Yes, given I said the information or the figures, statistics, that I think it was 70 to 80% of the summary sheriffs business is going to be criminal. That might well impact on those other cases in the civil remit that they're going to be looking at. Certainly this is why we're interested in proposals that specialist sheriffs deal with domestic abuse apart from anything else. But I think there will be a knock-on effect just purely from that programming.
Yes.
I'm anxious to avoid the difficulties that are experienced presently in the Sheriff Court, just being sort of put downwards to the summary sheriff, and the same difficulties appear in that court. And I mean by that the squeeze on civil and criminal business, unless both those areas are separated.
Thank you. Sandra Christian Roderick.
Thank you very much, Convener. Good morning, everyone. Specialism, just a small point on specialism. I think from hearing the evidence and looking at evidence from last week, people are agreed that it is important to have specialism. One question I wanted to ask all of the panel was, do you think training, obviously, and the will to want to do that, as Louise had mentioned, timescale-wise, in regards to training sheriffs up to that specialism? Do you have any issues around that? You know, regarding the timescale with Lord Gill's court reforms coming in, will there be enough time to train each person up to a particular specialism? And one of the areas I wanted to ask about, which hasn't been asked so far, I think Mr Brown specialises in this particular one, is about the housing. It's not clear how that's going to work. Obviously, the limit will be £5,000. We're also looking at the private housing bill, what will take, you know, the private tenancy part out of it as well. So, in Mr Brown's case, how do you think it will work in housing cases? Whilst they're saying it's downgraded, but obviously it's very important people, if they're, you know, going to lose their house or whatever it may be. I don't seem to see anything in Lord Gill's submissions or in the bill which covers, you know, the housing cases to an nth degree.
Understanding is that the defended eviction for landlord and tenant matters will be under the simple procedure. You can obviously be, it'll be more complex if the crave, if it's based on rent arrears and the crave for payment is more than the limit for simple procedure, which is currently 5,000. But the way I understand it is that the majority of defended eviction for rent arrears cases will be under the simple procedure, which will mean that summary sheriffs dealing with the simple procedure, particularly given they will have this inquisitorial role, which arguably they have at the moment to some extent, but they will have to develop an expertise, obviously not just in substantive housing law, but the relevant peculiarities of procedure, housing benefit, and so forth. I mean, my sheriffs that have an interest and an inclination, they're generally very capable lawyers. I can't imagine it needs a great deal of time to train them up to do it. And there are some sheriffs who already have a huge amount of expertise that could train their colleagues. So I don't see that as being a major problem, but I do see it as being something that should be flagged up as something that is required. I have a concern, I would just reflect what other speakers, the other witnesses have said, which is the mixing of criminal and civil is sometimes not a very happy mix. And I can see summary sheriffs that are very enthusiastic about dealing with eviction matters, family matters, not necessarily being hugely motivated to deal with summary criminal. I think there would be a role for dividing up the specialisms so that someone could be hired in order to do civil matters. When this whole area was originally mooted, that was how I understood it was going to be constructed, and I think that would be a much happier happier approach. As you say, particularly as the expectation is that they will go into, sheriff will go into a case with a high degree of expertise. I don't think it's reasonable, how would one put it, to pay a sheriff, summary sheriff, a bit less than the sheriffs and expect them to know everything that a sheriff currently deals with. The responsibility is the same. I don't think that's reasonable.
Say something. I'm mindful of time. And about training.
Just very briefly, I want to say that the Judicial Studies Institute of Scotland already has a fairly comprehensive training programme, and we were involved with them 2 or 3 years ago in developing a DVD based on the Canadian judicial training model in relation to domestic abuse, and they'd have a rolling programme. So I think certainly engaging with them to figure out how their programming would be carried forward, but I think there'd be commitment from them certainly to ensure that the judiciary were trained in the various aspects of specialism and otherwise that were needed.
Yes, yes, briefly, if I may.
I think it would be unusual to have an applicant for a specialist post who didn't come from that background, so I don't see that necessarily as being a huge issue.
And I think it's fair to say some sheriffs already indicate that they have preferences for the cases, and as you say, in Edinburgh Sheriff Court, you will have a sheriff who prefers to take family cases and takes them right through. Certainly from my memory, that happened. Christian Roderick.
Thank you very much, Convener. Good morning. Just a couple of quick questions. First of all, I heard your views on mediation on domestic abuse. But what about all the written evidence we received that some organizations have asked for alternative dispute resolution to be put on the face of the bill? Is it possible to exclude the domestic abuse cases? And would you think we should have that on the face of the bill?
I have seen some of the other evidence from various organisations who don't think that the bill goes far enough. Lord Gill, I think, actually said in his report, be back here, well, talking about, say, courts compelling, this was at Chapter 7, I think, at page 169 of the original review. We insist on the fundamental right of the citizen to have access to the courts. We do not consider that the courts have the power to compel parties to enter into ADR. That's entirely contrary, in our view, to the constitutional right of the citizen to take dispute to the courts of law. So you would have to be very careful, I think, what you put into the bill. And if there was any suggestion at all that it was moving towards ADR, we would specifically like domestic abuse to be excluded. But at any rate, I don't think, given this and given, I think, the access to justice issues, that putting that sort of compelling or presumption in the bill, I think, would be helpful in parties.
Even for at least one assessment meeting before a writ can be lodged?
Well, the assessment would depend upon the skill of the parties, and as we've also mentioned, the parties actually, or sort of the people before the mediators or whatever, actually discussing the issues of domestic abuse. And the problem is that women won't want to talk about it because they're scared. They are there with the partner who's abusing them. They have. Oh, you're nodding. You understand? Yes. So therefore, no.
What I wanted to do is, as I said earlier, excluding domestic abuse, but there are plenty of cases.
I think if there was any appetite to put that in the bill, then we would specifically want domestic abuse excluded. But as I said, I don't think that would necessarily be the way forward to put that sort of presumption or compelling notion in the bill.
I think without causing difficulty, it would be allegations of domestic abuse. That's the issue.
Yes, absolutely.
That's the problem. So you can't really sort of prejudge what courts would decide, even in a civil matter, in a balance of probabilities. So that's the issue about it. I think if you were to be as rigorous as to categorise that you're prejudging.
Well,
or just where there's an averment of domestic abuse.
Even an averment, yes.
Okay.
I think that the whole issue of domestic abuse is it's a very hidden issue. You're talking about people, women. Yes.
Point. You agreed with my point
Yes.
that at that stage it's an allegation of.
It is an allegation,
Yeah.
but of course the whole issue is taking it seriously.
No, no,
and
I'm not disputing that.
No, in relation to the proceedings. So,
Yes.
if by saying that we were going to put every case to mediation until it was almost to the satisfaction of the member of the mediator, not the parties, that domestic abuse was not an issue, I think you're also taking power out of the woman's hands.
Or the man's.
Or the man's, as the case
Yes.
may be. But in our case, we're talking about women.
I just keep the balance here, if you don't mind. Can I then, have you finished there, Christian, on it? Want to come in there?
Yeah.
Yes, sorry.
Generally speaking, you tend to find that you don't get all your clients coming in to see you and said, I want to go to court. The cases that tend to end up in court are those which have been tried before, and the timing of it is wrong. If you're at court, there are not many cases in which the parties are not so entrenched in their positions that mediation would be appropriate. I'm all for mediation, but I think it may be just the wrong timing.
Thanks very much, Governor.
Yes, I'm going to let other people, I just want you to be brief, if we may, both with questions and answers. Thank you, Mr. Brown.
Yes, I mean, this relates to judicial review because the time limit in the bill for judicial review is set as being 3 months. I think that's far too short and will preclude all the other forms of discussion, negotiation, mediation that could take place in a complex matter. If the time limit for judicial review goes ahead, and I would urge the committee to recommend it doesn't, the minimum should be 6 months, if not a year. If that was to go ahead, there would only be a matter of a couple of weeks at the most where any form of formal or informal negotiation could take place, because the procedure means that all the papers will have to be got ready well before the 3-month deadline. So effectively, parties will be locked into applying for legal aid, trying to get legal aid, or trying to get the funds together almost immediately. And in some cases where there's an emergency, that's fine. And we do a lot of homeless matters where if you're going to do judicial review or threatening, it's all a matter of a couple of days, hopefully. But in a more complex matter, particularly using the opening up of judicial review by the AXA decision, 3 months to try and achieve all that is going to be completely impossible. So the AXA case opened the door a bit, making it possible for community organisations, campaign organisations to take up cases, as they do in England. But the 3-month deadline in the context of our court procedure and our lack of tradition for judicial review in this way closes it again. And I think we need to think long and hard about that. I would urge, I think the absolute minimum time limit has got to be 6 months, if not 9 months. And my understanding of that is that of the bodies who've submitted written evidence, there isn't really anybody who supports the 3-month time limit.
To be very ignorant here, so I'm not sure about the process. I was looking at Rod to see if you knew. If you can't apply for judicial review, then insist while you either mediate or apply for legal aid. That's not possible. I don't know. I'm asking you. So you can't put a marker down, so stop the time limit running out, and then insist the proceedings while you deal with the other matters.
I think I can't see any reason why you shouldn't at the right point. But the procedure that we're told will happen, there'll have to be the application will have to be made, then it'll have to be served, then there'll be a permission hearing because it's not automatic, and written evidence in support of the application and copies of the documents. I think that will all have to be done right at the beginning.
Halting of proceedings, you can't
I
insist
don't
while
see
you
that.
do the other. I just wondered. Yeah.
I can't see that it will be in the interests of the system to basically say, apply for judicial review and then leave it all. That will just result in large numbers of inappropriate judicial reviews being raised to stop the time limit.
You've answered my question. I just didn't know if it was possible. Roderick.
Thank you, Convener. May I just refer to my register of interest, a member of the Faculty of Advocates. A very quick question just on adoption and permanence. The Advocates Family Law Associations take the view that adoption and permanence order cases should be removed from the list of family proceedings which is suitable for hearing by a summary sheriff. Comments?
conversations perspective, if the specialist is only to be a sheriff, we would agree with that. However, our view would be that specialism in family law should be for both sheriff and summary sheriff. In which case, so long as there is specialist knowledge, there is no reason why a summary sheriff couldn't deal with the whole remit of family law matters.
Anyone else? Yes?
Of course, the difficulty is ensuring that they are specialist enough, because I think those types of cases, adoption, permanence, really do require a certain level of specialisation. And whilst it is fine for summary sheriffs to deal with those if they have that requisite level of experience, that really has to, it's an important point, we have to ensure that they do have that level of experience.
Is it? Thank you. Well, that's thank you very much. There's no more. I'm not looking at them because if I say this, then somebody put their hand up. I just blinker. Thank you very much. That ends this evidence session, and I'll suspend till 11 o'clock. Give you a break till 11 for the next panel. Thank you. proceed. Can I move on now to a second panel of witnesses? We'll focus mainly on the provisions relating to personal injuries, of which we heard quite a lot last week. And I welcome the meeting Anne Rogerson, Chair of the Forum of Scottish Claims Managers, Dave Moxham, Deputy General Secretary, Scottish Trade Union Congress, Ronnie Conway, Coordinator in Scotland Association of Personal Injury Lawyers, and Robert Milligan, QC, Compass Chambers. Welcome. And I know that many of you were sitting through the previous session. Can I have questions from members, please? Roderick.
Morning, gentlemen. Perhaps I could just begin with the question of equality of arms and perhaps just invite you to commence, Mr. Rogerson. In your written submission, paragraph 13, you refer to recent comments such as trade unions being outgunned by the massive resources of the insurance industry and the big businesses they represent are simply not the case. In the reform system, there will be equality of arms and representation would be on an equal footing. For an insurer to do otherwise would make no commercial sense and the comment is highly misleading. Could you just amplify your thoughts on that point?
Mr. Rogerson, as you know, if I call you, your light will come on automatically to press buttons, and just let me know if you want to come in, the rest of the panellists. Mr. Moxham. Mr. Rogerson, sorry.
Certainly, thank you. What I would say is it's a myth that insurers will instruct counsel in every case. Insurers are obviously subject to market forces, and it would be financially imprudent of them to instruct counsel in every single case where the other side had a specialist personal injury solicitor acting on behalf of the claimant. So I don't see that insurers would do anything different and use their own specialist personal injury solicitors to deal with the defensive matters rather than try and outgun the claimant by use of counsel, where ultimately the insurer is going to be picking up the cost of it, of the representation on both sides. So I thought the comment was highly misleading, and that was the gist of the submission.
Like the rest of it.
No, I'm just looking. I know. I'm just looking if anybody else wishes to comment. Say perhaps the people think you use them as bully boys in court. You know, having counsel on one side, opposite solicitor on the other. Mr. Moxham.
It's not our experience. Our experience is not a particularly helpful one with respect to the actions of the insurance industry across a whole range of areas, and asbestos is one of those that we would frequently quote. We're particularly concerned that with the changes, which I'm happy to talk about with respect to section 69 of the Regulatory Reform Bill and its impact on common law proof that it will indeed be in the interest, the particular interest of the insurance industry over the next period to deploy their resources in a way which will affect the development of case law, much of which is now an open book because of the changes implicit in section 69. So as well as having a negative past experience of dealing with these problems, we have some significant worries about what the future would hold.
Yes, Mr. Rogerson.
I think it's a question of proportionality, and the sort of cases that Dave mentions there in terms of asbestos, for example, mesothelioma cases, these, you would expect a mesothelioma case to be over the exclusive competence of the Sheriff Court and then be the Court of Session. Now, if there was matters raised of clear law and the Enterprise and Regulatory Reform Act, where it's changing health and safety law, these would be clear examples of cases where the Sheriff Court could be using the remit to put those cases up to the Court of Session, where the Court of Session then has more resource at its hand to deal with these cases and deal with them quickly and efficiently. So it's proportionality. The question of counsel in every case, on the low-level personal injury cases where it's whiplash, for example, there's no suggestion that either party would use counsel or should use counsel for those. It's not proportionate.
Does anybody else wish to comment on that? Yes, I'll take Mr. Conway, then Mr. Milligan.
Thank you, Madam Chair, and thank you, Committee, for the invitation to speak today. The current position whereby in the Court of Session you have automatic sanction for counsel for cases of over £5,000 is indefensible. No one is suggesting that that should stay. Mr. Rogerson says that the limit should go up to £150,000 and that automatic sanction for counsel should only be available in cases over £150,000 in the Court of Session. The Civil Law Review and the policy memoranda talk about low-value cases, moderate or modest value cases and high-value cases. The problem is not the low-value cases. Everyone has agreed that those cases should be out of the Court of Session. There may be some matters where even a modest value case, £10,000, £15,000, might require counsel. I don't have a problem with the test which is proposed in the Taylor review. I should perhaps declare an interest that I was part of the Taylor review, but the idea of...
You're agreeing with it.
It's an excellent test. But the question is, where do the modest value cases go? Modesty in every walk of life is a relative concept. And the idea, which appears throughout the policy memoranda here, that a case for £50,000, £100,000, £150,000 is a modest value case, with respect, is simply absurd. So that certainly
to tease out the monetary level,
yes.
what your view is of that, and
yes.
then the other part, which is counsel, okay. and which seem to be two parts that there. So, have
yes.
you got a different limit you would suggest for privative or exclusive jurisdiction?
There should be a different limit. I mean, if I may say, you look at the policy memoranda, you look at the financial memoranda, you look at the explanatory notes, and what I see is this. There will be judicial salary savings of £2 million after all the summary sheriffs are in place. The legal aid board, the public purse, will save £1.2 million. The personal injury clients are simply to have a change of venue. They will still get a Rolls-Royce system. There will be a few lawyers who may do a bit less well out of a system which they appear to have worked to their advantage. And I suggest that reading that you think, well, what's not to like? The problem is saying it, and it's said again and again, does not make it so. The PI court, the personal injury court, could work, but it is grossly underfunded. The civil court review analyses and describes a system which is slow, inefficient and expensive. Those criticisms, I can only speak from the personal injury perspective. The slowness and inefficiency does not apply to the Court of Session. It is a Rolls-Royce system. The challenge is to replicate it in the Sheriff Court. That cannot be done without paying for it. The savings to the legal aid fund of £1.2 million are completely illusory. The point about the £1.2 million, and it's made in the financial memorandum, is that it would appear that the public purse will save £1.2 million. It is just complete nonsense. 85% of cases are, in terms of the memo, in legal aid cases, are successful. They are paid for by the defenders, who are the repeat institutions, local authorities, utilities like Scottish Water, the people who Mr. Rogerson represents. So there will be a saving, but it is Mr. Rogerson and his clients who will make the saving.
£2 million that's not a net figure.
It's not a net figure.
Okay.
It's an accounting protocol. It is not a net figure. As far as I read the figures, there is £5 million. The Legal Aid Board say they spend £5 million on reparation. It's in the financial memorandum. I think it's paragraphs 94 to 97. They say that 85% of cases are successful, which means that the true saving, at best, would be 15% of 4.9 million. And even that amount, the Legal Aid Board already has it within its power. And I can say from my own experience, you first of all have to get a Court of Session legal aid certificate. You have to prove that the case is transparently worth more than £50,000. To get legal aid in the Sheriff Court, there is a whole list of stringent requirements. So the idea that the public purse will be saving £1.2 million is simply wrong.
You haven't answered my question about the limits. I mean, you've talked about the money
the limit,
savings
yes.
are illusory. Can you get back the limits?
You're quite right, Madam Chair. The point about that I would make about the limit is that the data on which, perhaps I can start off from what the civil courts review said about how they would like to see the court system, what they would like it to look like. And they said it should be 65% of cases should be downshifted from the from the Court of Session to the Sheriff Court, leaving 36%. The policy, in the policy memorandum, this figure has moved, so we now see it's 80%. We say, on the figures which we have looked at, that around 95% of cases will be downshifted. The figures which the Civil Law Review rely on are admitted in the review to be weak and, in some areas, I would suggest, unreliable. They come from an insurer database. There's all kinds of caveats in the Civil Law Review. From reading the SPICE briefing, they tried to interrogate these figures, and they were told that these matters were subject to confidentiality. APL carried out an anonymised test via a well-recognised law accountant who acts, Alec Quinn and Partners, who acts both for pursuers and defenders. The figures which we, and of course the important point is the settlement figure. It's not the sum sued for, it's the settlement figure. And what our figures show, and they're attached to the APL, I don't want to bore you with the detail of the figures, but the headline is they looked at 53 cases, looked at where the settlement was, and they found that in only 2 of the 53 cases was the settlement figure over £150,000. That if you wanted a court which looked like 65% Sheriff Court, 36% Court of Session, the figure should be between £20,000 and £30,000. We say £30,000, and as I say, the detail is in the written evidence. So I hope I've answered the question, Madam Chair. I appreciate I've gone on to touch.
I'll let. No, it's fine. I'll let Mr. Milliken, then I'll let Mr. Rogers, and then I'll come back to Roddy because you want to come in, Mr. Milliken.
Yes, the first point I would like to make is that historically, victims of personal injury accidents have had the right to representation by counsel, even at a low level. And historically, they have also been protected by health and safety legislation. Now, it would be a very unfortunate double whammy if the Westminster Parliament, having effectively removed that health and safety protection, the Scottish Parliament then removed that historical right to representation by counsel. Now, I accept Alan Rogerson's point that where you have a specialist personal injury solicitor acting for the pursuer, you may well have equality of arms, but many times, of course, a victim will go and see their local solicitor. If they don't happen to have a specialist personal injury solicitor nearby, they will see their family solicitor. And the historical advantage has been they have always then had the availability of an independent referral bar with specialist skills in this area who are able to help them right from the outset. And even in low-value cases, that can be very important. To give an analogy, my son recently fractured his wrist playing football. I took him for an X-ray to the fracture clinic, and I was surprised to see a consultant orthopaedic surgeon reviewing the X-rays. Now, of course, that's not because a junior doctor or even a nurse couldn't review the X-ray, but they'd obviously worked out it was cost-effective in the long run to have somebody specialist in at the outset to make sure that the initial diagnosis is correct. And it's precisely the same in a personal injury case.
Got a QC for a father that specialised in personal injury, which sounds more like it. You recognise the names.
I specifically asked because I was surprised to see a consultant orthopaedic surgeon, and he explained to me that that was the reason, was because in the longer run it was cost-effective.
We'll interpret it as we will. Sorry, yes, you're quite right. There was a real point, yes.
So I hope that you can see the analogy there. And just finally to pick up on, I suspect we would all agree that nobody would criticise the service that is currently provided in the Court of Session. Indeed, the criticism seems to be it's too good. And personally, I'm in favour of a personal injury court, but I would like to see it being as good as the Court of Session, just a cheaper version. I would like to see people litigating in the personal injury court through choice, not because they've been forced to. I would like to have a more positive view of the personal injury court. If it's good, then you won't have to be forcing people into it because they'll want to use it. As at the moment, they have the choice between the Sheriff Court and the Court of Session, and people use the Court of Session, they vote with their feet because it offers a better service.
Mr Rogerson, you wanted to...
Yes, just a couple of points. First of all, to pick up on Robert's Court of Session point, I would take issue with the fact that the Court of Session is completely smooth running and there's no bumps and lumps along the way. I've certainly got cases just now where all the evidence is ready to be heard by the court, but the proof dates are off into the middle or late 2015, simply because the court doesn't have capacity to hear those cases. So, and as the Justice Secretary actually said in the papers today, for me it's all about the right cases are heard in the right courts at the right time, as and when they're ready. So it comes back to proportionality again and the efficiency of the system. And they need to have the new Sheriff Personal Injury Court to free up some of that time in the Court of Session to deal with the enterprise and regulatory reform issues and the health and safety issues, which will be groundbreaking in the next couple of years. And it's right that those issues where people receive proper representation by skilled advocates, for example, and that should be the aim of the new Court of Session as and when these reforms come in. And just to come back to the point of the exclusive competence, the one thing I would sort of say here, it's very, very difficult to work out the difference between a case that's worth £30,000 and say £75,000 at an early stage of the case. You'd be relying on a specialist sheriff to try and determine that when they don't have the evidence in front of them, they only have the pleadings. Now, the £150,000, whilst it may seem high, does actually set a clear bar whereby you're suggesting that a claim to then go over the exclusive competence would involve future losses or someone who can't return to the occupation that they enjoyed before or requires some future level of care. It's not going to take into account cases where all the injuries in the past and that person has recovered and went back to work, whereas a case within the 30 to 75 realms could involve something where the injury is essentially behind the person and you're just talking about numbers by that point.
I do say I've got experience of a personal injury case which looked like a very simple whiplash and turned out to be a twist of the spine eventually, I mean, and it much more complex. And so I appreciate that what you aim for is really high to start with, because you sometimes don't know where you're going until the medical evidence has all come in over a long period of time sometimes. Can I just ask you something that you said about, you know, it's not all without bumps and lumps in the Court of Session. One of the things that was put to me is that the Court of Session, with its expertise, does in fact expedite personal injury cases, but transferring them to the Sheriff Court might mean you have long continuations over a period of time and disrupted proofs, so that in fact it becomes extremely difficult to get the same sheriff hearing the case over a period of time with the burden of work in the Sheriff Court. Is that not an issue where there might be more bumps and lumps in the Sheriff Court?
Certainly in the present system, yes, that exists. But this is in terms of what the Court Reform Bill is doing, setting out the new personal injury Sheriff Court, where you'll have specialised sheriffs who will be trying to hear the case in one go, as opposed to dealing with continuations and hearing it a day at a time. Because I totally accept your point, that would be completely unsatisfactory for everybody involved if that was to be the case we end up with.
We not already have specialist personal injury in the Court of Session? Is it not just relabelling it?
We do have specialist personal injury in the Court of Session, but the problem is that's also dealing with low-value cases. So you're using that high-value Rolls-Royce service for a case that's not necessary to have that kind of service.
Mr Milligan and then Mr... Well, we'll take Mr Moxham. You've not been in for a while.
I want to make another point, but could I just in passing refer the committee to the report in the shadow of the Small Claims Court, where it's clearly found that insurers employed the best possible counsel in small value, best possible solicitors in small value cases, and that's a matter of record, and it's something that a number of the people who provided evidence refer to. But the main point that I wanted to come in on is the importance of the points that Robert Milligan made in terms of replicating or attempting to replicate all that is good currently within the Court of Session, if it is indeed the view that a specialist personal injury court is to go forward, and that refers in particular not just to time, but to the, if you like, the back office, for want of a better term, the kind of electronic other systems that are made available in the Court of Session, which I know that the people who act for us find particularly useful and efficient, and it seems to us that that makes the case, amongst other things, for the citing of any new personal injury court in the current Court of Session.
Mr. Milken.
But yes, the point I wanted to make is that if a case is low level and it's not complex, it will settle. It will probably settle before any type of litigation at all. Most cases do. And if it does get to litigation, it will settle very quickly, because I act for both pursuers and defenders fairly equally. And I know that both sides want cases to settle quickly. Neither side has any incentive to drag a case out. So a low-value, easy case will not use up any court time wherever it is.
Yes.
Madam Chair, may I just speak about the experience of our members in the Sheriff Court? If we start with the Civil Court Review, it has already identified slowness and inefficiency as endemic in the Sheriff Court. How on earth is the addition of some 2,500 or 2,000 to 800 cases going to improve that? And the point that you made, Madam Chair, is extremely well made. Routinely,
I'm not allowed to give evidence.
You're not allowed to give evidence. Well, it was a good question in that event. In the Court of Session, there are 4 days allocated for proof. The defenders know that there is a no excuses culture. There will be no adjournments. They know they're going to have to go to the dentist at some time before that 4-day proof. There are other settlement drivers which were identified in the government research, which the Court of Session has, which the Sheriff Court will not have. But the existing system is in crisis. It's in crisis. What you're being asked to approve will turn it into a train wreck. I do not apologise for the apocalyptic language. That is exactly what will happen. There is an example given in the April evidence briefing where a single day is allocated, the case proceeds, it needs a further 3 days, 2 days are allocated. On the day before the trial is to start on the second day, we're advised that the sheriff has got to deal with a jury trial which is running over. So those 2 days are lost. It bounces about in court for two separate procedural days whilst they try to fit in a hearing. And then finally, it's dealt with. I think for 4 days evidence, 4 days evidence took the best part of a year. I'm not quite clear on the specifics. It's in the April submission. That is not unusual, and it's because of the pressure on criminal business, of family business, etc. The scoping, the PI court, as it stands at present, what you've been asked to vote for, this is a court which is seriously underfunded. There is no new resource here. All that's happening is that pieces are being moved about the chessboard. One reads on the one hand that these cases are clogging up the Court of Session, and that they consume judicial and administrative procedure. And on the other hand, that by the time they get to the Sheriff Court, the effect will be minimal. Now, both parts of that sentence cannot be accurate. The scoping for the personal injury Sheriff Court is 200 days. That is the equivalent of a single sheriff at 205 days. Quite apart from the procedural issues, they are going to be inundated with arguments about whether counsel can be sanctioned. We ourselves have, or my firm has tried to get sanction for counsel in advance twice, both in asbestosis cases. It has been refused twice, mainly on procedural matters. One of the defects in the current law is that effectively the case cannot be sanctioned as suitable for counsel. Every single step of the procedure has to be sanctioned as suitable for counsel. So there's going to have to be serial applications at every point of the procedure. But the point I would make with respect to Mr Rogerson is the insurers are sniffing blood on this, and these motions will be contested.
But please proceed.
The big winners out of all this are the insurance industry. So I'm really not prepared to back down on that point. And you will see again and again the sanction for council opposed. If they can oppose it in an asbestosis case, what do they think is worthy for sanction for council?
Now, before I see the bloodhounds come in here, having sniffed it, can I go on to the next question and then we'll come in, because we've got quite a queue. Elaine, followed by Alison, John Finney, and sorry, Rod, I beg your pardon.
Well, just briefly, I don't know any comments on a number of people put written submissions in on competition issues in relation to current arrangements between council and parties, speculation agreements in terms of litigation. I don't know whether Mr Milligan wants to comment on that.
Yes, I would, because in Scotland, I think we are unique in having a requirement for sanction for council. In pretty much every other jurisdiction, it's automatic. It's automatically assumed that council will be required. Now, of course, there's then an issue about the level of fees that are incurred. But, of course, the bill does envisage, the Gill review and the bill envisages that that will itself become a matter for regulation. There will be control on council's fees. So, in my submission, that is the way forward. In the past, perhaps the competition issue hasn't really arisen because sanction for council has been automatic in the Court of Session, and that's where most personal injury litigation is raised, even low value. If it is moved into the Sheriff Court, then that issue will arise very starkly, because it is clearly anti-competitive. At the moment, an advocate can't compete with a solicitor for work in the Sheriff Court.
Thank you.
Are you talking about advocates taking a pay cut?
Much though it pains me, I think that's an inevitable consequence. I don't necessarily shrink from that. What I do shrink from is being denied the opportunity to compete for this work.
Okay, yep. Right. Elaine, followed by Alison.
Thank you. I think both Compass and APIL have raised doubts about this hope for savings in the financial memorandum, arguing that actually the exclusion council can't be justified on cost grounds because most of that is actually recovered through the awards of fees and so on. So I was wondering if you think we should examine that with some degree of caution.
Again, if I may, just to pick up on the point that Ronnie Conway made earlier about legal aid funding, there are two difficulties with what's mentioned in the financial memorandum. The first is, as Ronnie says, 85% of that is recovered anyway, so it isn't actually spent by the government. And the second is that at the moment, legal aid is very seldom allowed in anything other than the most serious personal injury cases. And I don't see why that will change. You don't get legal aid for straightforward or low-value personal injury cases at the moment. So it's anticipated that there will be a 50% saving. I don't know where the 50% comes from. I don't see that there will be any saving at all to the legal aid budget.
Just to say, we have the Legal Aid Board coming in front of us, so we can raise this with them as well. Mr Conway? I'll take Mr Rogerson first, not that I'm in any way penalising, but because you made that remark, I'll take Mr Rogerson first.
No, it was just, I'm certainly not sniffing for blood or anything like that, I'll quickly add. I just wanted to, first of all, endorse a point that Robert said that earlier on, that insurers actually want cases settled and rightful compensation paid to injured people. They don't want to end up in litigation any more than the injured person does. And it's quite telling that the court statistics for last year, there was 8,725 personal injury actions litigated. So to my mind, that's not satisfactory from an insurer or an injured person's perspective. And it's a misnomer to sort of suggest that insurance companies will be picking up the tab and paying the expenses here, because of course the cost of insurance goes back to the consumer or goes back to the business that pays their insurance premiums in the first place. So there's not a windfall here for the insurers.
Yes, now, Mr Conway.
Well, if I can very briefly pick up on what Mr Rogers says, if they're so desperate to settle these cases, why do 98 out of 100 of them only settle after proceedings are raised, many at the door of the court? Secondly, he's absolutely right. This is not a victimless crime. Insurance premiums should be appropriate. There's no, from our perspective, low-value cases should be taken out of the Court of Session. That is where they are being, where expenses are inappropriate. I've already made my remarks on modest value expenses. I think I've already, insofar as I can, covered the Legal Aid Board point, but there's a further big point about the finances here. The Court of Session, as it stands at present, is largely funded by personal injury actions. The fees funds which it receives are something like 4.6 million. 2.3 million of those fees relate to monies paid by parties in Court of Session actions. The analogous amount in the Sheriff Court is £804,000. That's what is taken in by Scottish Court Services for the Sheriff Court. On our figures, and we've done some, since the call for evidence, we've done some basic scoping, which I'm quite happy to make available. But on our figures, there will be a net loss to the fees fund of £1 million. The only way that £1 million can be made up is by a substantial hike in Sheriff Court fees. When Lord Gill appeared before this committee, he was asked by Ms Mara, well, will thousands of cases not disappear from the Court of Session? What is to happen to the fees? And it seemed to me that he said in terms, well, you'll be getting a quality, the people will be getting a quality product, they should be expected to pay for it. I have no problem about being expected to pay for a quality product. What is on offer here is not a quality product.
Is it not the case, though, that the government would argue that that they would be substituted by commercial cases? Do you think that's likely?
No, I do not think it's right. The problem, it's said time and time again that the personal injury cases are preventing high-value commercial work from coming to the Court of Session. Simply saying something does not make it true. It is simply an assertion. The problem about commercial work is this, that 500 miles from here, in London, there is an international centre of globally accepted excellence. Throughout the world, and it gives me no pleasure to say this, throughout the world, contracts are written in terms of English law, and the English Commercial Court exerts an enormous pull on litigation throughout the world. In fact, one of the complaints about people in England is litigation tourism, that they're having to fund people coming from around the world to use the Commercial Court. When the International Centre was set up in Dubai, an international commercial and arbitration centre, it was set up in terms of English commercial law. It was set up by importing Lord Woolf and a whole cadre of English judges. The idea that simply by saying we are now open for business, the Court of Session is going to attract a huge number of quality cases is simply a fantasy.
Mr.
Yeah, can I say that not only is our advice in complete agreement with that vis-a-vis potential commercial activity, but we do actually have excellence already in the Scottish courts. We have excellence in PI, and we have people from certainly around Europe and certainly across the UK who look at what we do. I'd rather nurture the centre of excellence that we've got and the reputation and other value that provides for us, rather than going on fishing expeditions for commercial work.
So you sort of agree. You sort of agree with them. Yes, Mr. Rogers.
I actually completely agree with both points that were just made. But we do have an excellence in Scotland. My problem's with the proportionality that we currently have. And we did some statistical analysis of our cases, which we looked at over 8,000 settled litigated cases. And on the cases that settled for under £50,000, there was £1.56 paid out for solicitors' costs or legal costs for every £1 the injured person got in compensation. So to our mind, that isn't proportionate. At the low levels, that's where we need to do something and change the mechanism, and that's where the Court Reform Bill will help.
I'm going to take Alison, John Finney, then Sandra. Alison,
thanks.
please.
Well, just sticking with the personal injury court at the moment, Mr Rogerson obviously very comfortable with all of the proposals and you know, decreasing interest and support for it as we go along the other witnesses. So what was helpful to know is what safeguards or what amendments would you like to see to the bill to make it work, to make it as efficient as you would like to see it?
Who wants to start with decreasing support? Yes.
I would like to see the exclusive competence reduced to £30,000. And the main point, I'd perhaps been unduly critical of, there's no problem about the vision thing, so to speak, in the proposals. The problem is in the detail, and the problem is in the funding. The PI court at present is simply not funded. The idea that all these cases can cascade down and will seamlessly be accommodated in a system which has already been analysed and found wanting is not correct. So if we've done again some kind of basics, you know, I haven't even started about the IT provision. You look at the civil law review, and it is hugely critical of the Scottish court system as far as IT is concerned. I think, as one of my colleagues said, we are barely in the Sheriff Court, we're barely in the analogue age, never mind the digital age. The civil court review wanted wholesale technological improvement. The budget for the IT investment in the personal injury court, and it's not just one court because there'll be personal injury centres at each of the 16 sheriffdoms, the total budget is £10,000. Now, I've no idea how that £10,000 is to be spent. I run a small to medium business. I cannot conceive how that can be an appropriate figure. Yes, we could have a lot of them. We could have a lot of them.
Yes.
The impression, and I will just say this, is that the government has seen, or to be more accurate, the proponents of the legislation have seen the promised land, so to speak. They like what they see. The figures have then been crunched, and suddenly there is a retreat from the principles in the civil court review. And you see it at every turn. You see it as far as the PI court is concerned, the specialist court which is not funded. You see it as far as investment in IT is concerned. You see it in the Sheriff Appeal Court, where the original proposal was that there would be 3 judges of sheriff principal level dealing with cases. We now find that far from that, there's only going to be 1 sheriff. The appeal is going to be to a single person. And if you look at it, that person might simply be another sheriff. So that if everything comes to pass, you could raise a case for a fatal case, a widow, for £150,000. You could lose on the merits in front of a sheriff. You would appeal. You would go to another sheriff. You might lose there. You would find it well nigh impossible, I would suggest, in terms of the current rules, to get to the inner house of the Court of Session, because you'd be told, well, what's happening here is not exceptional. It's simply the courts or the sheriffs have simply applied the law, or the argument might be misapplied the law. That doesn't give you grounds to go to the Court of Session. And the kicker is, in terms of the legislation, they can say that the business exigencies which exist in the Court of Session might trump that.
I'm just checking. I think there can be more than one sheriff sitting
There
in
can
the
be.
appellate
There can
courts.
be. The original proposal was 3. There can be, but I'm not able to put my finger on it, but it's in either in the policy or the financial memorandum. It says that it's expected to be one person.
Yes, but then even in the inner house, you can have, what's it, a bench of, Roddy will remind me, a bench of 3, a bench of 7, a bench of...
I think the government's position is that in 95% of the cases it will be just one sheriff, and 5% it will be a kind of multi-member bench. So that's how they see it panning out.
Yes.
Yeah.
That was my recollection.
Are there not advantages in having an appellate court, sheriff level, for the whole of Scotland, rather than having sheriff principals perhaps being a bit different about their view of the law in their different sheriffdoms?
Yes, there are advantages. The Civil Law Review was correct. It points out those advantages, that a bench of 3 by definition is more likely to get it right than
Nationally applicable,
absolutely.
rather than just within the sheriff.
Yes, and it will create some kind of, it should create some kind of consistency. I have no problem with that. The problem, again and again, is the implementation. Am I being cynical in thinking that the full implications of the resources have suddenly dawned on the proponents of this legislation, and they have just decided to put a quart into a pint pot?
Okay, Mr. Rogerson, and then Mr. Moxon.
Just back to the original point, the one aspect I'm uncomfortable with the Court Reform Bill is the issue of jury trials in the civil courts. To my mind, that detracts from the idea of efficiencies and calibre of justice that you would receive in the personal injury court, and back to the heart of being proportionate, because if you have a low-level personal injury case that's a whiplash case or something where the injuries are fairly minor, to then have an entire jury trial procedure to decide damages for that case just seems completely out of all proportion. And I think you would perhaps lose the efficiencies of the system there.
Anyone else wishing to come? Mr. Moxon,
if we're still on how we would construct a personal injury court, that would give us some, what's the word I'm looking for, some comfort, then all cases which were workplace personal injury cases would have the facility to be heard in the special injury court. We think that was the original intention of a whole range of contributors to this whole process. There would be automatic right to counsel for cases of over £5,000. We also think that it would make sense, as we say in our submission, to continue with a situation where asbestos-related cases were heard in the Court of Session for a whole range of reasons, which can be more eloquently put, I'm sure, by Clydeside Action Asbestos and other practitioners than me. And just to repeat the point about resourcing and support, it has to be ready to go, and there's a great deal that needs to be done in terms of resourcing and readiness if that's to be the case.
So, modesty was going to prevent me from raising the issue of sanctions for counsel, but since Dave Moxon has already done so, that seems to me to be the most obvious safeguard. Indeed, it would be a great shame if we set up a specialist personal injury court and then excluded from it the very specialists who currently make the system work. As far as the exclusive competence privative jurisdiction is concerned, I do agree £150,000 is too high. I think the Spice briefing gives it's a very good document generally, but the critique of the statistical basis for £150,000, I would certainly commend the committee to read. To a certain extent, it doesn't matter so much if there is ready access to counsel, because then we're simply replicating the situation that we currently have. And again, I make the point that surely that's what we want. We want to be encouraging people into the personal injury court, not forcing them in. And then finally, the question of resourcing. It is absolutely essential that this is set up and ready to go before there is any increase in the exclusive competence, because there is no doubt that the current sheriff court system does not work for personal injury because of this business. You get one day, you then wait months for another day, by which stage everyone's forgotten what happened on the first day. So it's essential that that is set up and ready to go before the work is moved into it.
All right, Mr Conway, I see you. Yes.
It's because, Ms McInnes, there's quite an important part of the answer which I forgot to give. And it is this, that cases under £5,000, the proposal, as far as I read it, it's not absolutely crystal clear. The proposal, as far as I read it, is it should be part of the simple procedure, which I think the committee has already heard the consumer groups and the charity groups argue should be, the sheriff should adopt an interventionist, inquisitorial approach. Matters could be dealt with in a single day. The sheriff should mediate or negotiate settlement. Now, it would appear that personal injury cases of £5,000...
I think was what the sheriffs made it plain they don't want to influence.
Yes, it's important. I do take the distinction. It would appear that cases of £5,000 and under, of which there are a great deal, they constitute the biggest number of cases in Scotland generally, and around a third of all cases are under £5,000. Now, we know that simple procedure does not work for them. We know it because research was carried out by the researcher, the government researcher Elaine Samuel, and it's called, I think my friend referred to it, In the Shadow of the Small Claims Court. Unrepresented litigants do not know how to identify a cause of action, do not know the law on employees' liability, statutory liability, occupiers' liability, do not know that they will require to provide medical evidence, do not know how to bring
hurdles for party litigants.
Yes,
most, not all, but most, yes.
So that, and in fact, it's been acknowledged in the sense that just now all of these cases are summary causes, and there are a special subset of summary causes, which has a special set of rules. And what we say is if the personal injury court is to be set up, it should not be dealt with by summary sheriffs. It should not be part of simple procedure. It should be incorporated into the specialist court, either the All Scotland Personal Specialist Court or the courts around the country, where you will have expertise and economies of scale. It's simply the idea that these cases will resolve is not accurate.
I just pick you up, and just Mr. Ross, I think you said claims of 5,000 over should be the automatic right to counsel. Is that correct?
No, I didn't say that.
No, you said that. Yes. Can I ask you then, Mr. Moxon, will it not be just the case that people will ask for 5,000 or more simply to get automatic sanction of counsel, notwithstanding what they settle for at the end or what the claim is really worth?
I mean, that's a point that I personally hadn't particularly considered, and I'd be happy to get back to you on that specific point. But it does seem to me that the situation that our people will find themselves in, if there isn't some automatic right to counsel set at a specific limit, is that they may find themselves surprised by counsel, and they may find themselves having to retrospectively apply for counsel in a situation which they didn't predict was going to happen.
I was making, though, of course, if I were acting and I thought that 5,000 over you're going to get automatic sanction of counsel, I might just put that in for the start.
I mean, the other, I suppose, obvious point being that they'd be penalised under costs of recovery.
At the end of the day, yes, but nevertheless, Mr. Milligan.
Yes. Really, the point I wanted to make is that the test is not the sum sued for. That doesn't decide whether you get sanctioned or not. It's what the case is worth. And we do set out the test in the Compass response and make that point.
Thank you. I'm going to... did you finish, Alison? Yes. John, followed by Sandra, followed by Margaret, followed by Christian. John, sorry.
It's a question for Mr. Moxon.
I'm about to delete somebody. That's fun. Oh, you did it for me. I lost my time. John.
Yeah, okay. A question for Mr. Moxon. Mr. Moxon, in your evidence, you talk about Scottish courts having produced a disproportionate amount of case law in respect of health and safety. You also talk about section 69, and that was mentioned earlier in evidence. You also talk about workplace injuries being more than the individual redress being sought. And you talk about, in your evidence, you say that as a result of section 69, workers who are injured as a consequence of an employer's breach of a statutory duty within the Act's regulations will be prevented from enforcing that breach. Now, I personally wish you well your complaint to the European Commission. What is ultimately your preferred forum for dealing with this? I note what you say in relation to Council, but can these issues be dealt with in terms of this legislation?
They will still, they will be affected by the legislation, and it's not absolutely clear how our people pursuing cases will attempt to deal with all of the implications of Section 69. They will certainly have to rely more on proof of negligence. They will certainly have to rely more on medical expertise. They may have to rely more on other pieces of legislation, such as European directives, in order to try and, if you like, tip back the balance and create a body of case law that, to some extent, we hope replaces the strict liability that existed previous to October the 1st. Our difficulty with this is that we think that the broad thrust of health and safety legislation and European legislation has implicitly recognised the disproportionate relationship between the employee and the employer. That is to say that in a perfect world, the employee would have far more choice over the machinery, the systems that were actually put in place in the workplace. The fact is they don't. And therefore, historically, we've seen the way that legislation has been constructed and then interpreted at, to some extent, redressing that balance and having the very positive additional effect of creating a culture of health and safety, of safety first, if you like, which we think is to the value not just of our members, but of to society more generally. Now, I've been doing a little bit of reading around some of the commentary from insurers and friends of insurers around this. Yeah, yes, exactly. And certainly one of the things that one of the things that they consider within this are the prospective impacts of employers, number one, beginning to say we can relax a little bit. Now, that is not the fault of anybody in here, but it's undoubtedly been very clear messages coming from Westminster that the culture needs to change, that employers can relax. We believe.
Safety monster, I think, was the term.
Yes, yes, exactly. We also imagine that in a number of cases, clients will ask their insurers to contest cases that they previously wouldn't. And, of course, we will be in a position of having to reach different tests in terms of negligence and liability. That creates, in our view, irrespective of your view about whether Section 69 is a good thing or not, and I think I've made mine clear, that creates an incredibly complicated playing field, a complicated playing field in which it will even be difficult to assert which are the important test cases and which aren't. In our view, to undertake any of that work under simple procedure would be fundamentally wrong, and to recognise the importance within the new Sheriff Court, Specialist Court, of access to counsel and other important mechanisms that would make that court a good court are particularly important in the next period. If it was the case further down the line that by statutory instrument or otherwise, if you like, things were seen to settle down, then the Parliament again wanted to look at the situation in 5 or 10 years' time, that might be a reasonable thing to do. But this is a crucial period in terms of creating the right health and safety landscape in Scotland and frankly across the UK as well.
I would agree entirely.
Who are your friends, by the way?
I'd agree entirely with Dave that this is not a time for employers to...
Is that a friend?
I don't know. We'll see afterwards. I would agree entirely that employers should not be taking their foot off the gas with result to health and safety in any way, shape or form. And it's certainly not insurers' interest that they do so as well. And I think in terms of the court reform bill and what we have here, that there is the case that the enterprise regulatory reform cases where there would be groundbreaking health and safety cases, you would be applying for sanction for counsel, or you would be applying for remit to have it heard by the Court of Session in a new, efficient court, then hopefully you would hear it quicker in the new Court of Session as well. And that way we keep the groundbreaking Scots law to the fore.
Can I ask you therefore what you understand by exceptional circumstances, which I think is the test you've just mentioned, sanction?
The test for sanction for counsel is the employment for counsel is appropriate by reason of circumstances of difficulty or complexity or the importance or value of the claim. That was Sheriff Principal Taylor in his review and expenses set that as the test, and he summed it up that way. So clearly we're talking here of matters of importance. Not necessarily value of the claim, but clear importance, not just to the individual, but to society in general.
Different from exceptional circumstances, or is it the same?
Well, I think you could argue it's the same.
It's the same.
If it's important to society in general.
Mr. Milligan, you don't agree?
No, funnily enough, I don't agree. But I do think that illustrates exactly the difficulty once you start just having a subjective test like this for sanction for counsel, because to what one sheriff seems like an important matter, to another sheriff might not be, and the litigant doesn't know that until it's too late. So I just don't accept that that is a sensible and fair way to somebody who, after all, has been injured through somebody else's fault, that they might be penalised in that way.
But then they could appeal. They could appeal against counsel not being sanctioned, surely.
In theory, appeals on expenses, there's plenty of authority that they are actively discouraged, and quite rightly so, because expenses are very much seen as a discretionary matter.
Mr. Conway, yes. You don't need to be discreet about it. Now, I know the hand gestures that are coming from you.
Thank you, Madam Chair. If April's figures are correct, and we say they are robust, 95% of cases will come out of the Court of Session, and the Court of Session will effectively end as a court of first instance. We had no problem with the original scoping of 65, 35, 35% left. It will end as a court of first instance. You talk about the prestige of the court. My friend, Mr. Moxham, is correct in that Scotland has led the UK in the field of health and safety for well over 100 years. Abolition of common employment, safe system of work, the dust and disease cases in the 60s and 70s, the health and safety cases now. Donoghue v. Stevenson. Donoghue v. Stevenson. Now, I read in the...
that was in the ginger beer, it was the...
The snail in the bottle.
Yes.
It is the snail in the bottle. And there is... we're all laughing. It's the most famous common law case in the world. The policy memorandum says it started out in the Sheriff Court. I beg to differ. It started out in the Court of Session. It was dealt with by a Lord Moncrieff who went against the conventional wisdom that a manufacturer of foodstuffs had no duty towards the persons who would eventually consume that foodstuff. He was eventually found right by the House of Lords against all the conventional law and invented, so to speak, product liability. Now, the point is that a Lord Ordinary, by reason of ability, the absolute top of the profession, by reason of temperament, by reason of self-confidence, will make the law in a way in which, with all due respect to them, sheriffs, by training, by inclination, and by the court system, must defer to authority.
I'm just thinking Sherwood's reaction to this when he reads the evidence, but you go for it. I hope you're never in front of him.
Yes, indeed.
No, please, don't feel inhibited now.
I'm not, but I take the point. I'll be avoiding Sheriff Wood. I'll be avoiding Sheriff. The point is the system will not let him do that because he will be bound to be applying the law as it is instead of making the law as it ought to be. And that is what the Court of Session has done.
You've saved yourself, yes.
That is what the Court of Session has done for hundreds of years. So if we lose that is an important thing. It seems to be being tossed away without as much as a backward glance, quite frankly.
John, still you, isn't it?
Yeah,
We've
it's a
got
very
lost
brief,
because
if I
I've
may,
got
please.
Margaret and Christian, yeah.
I just would like the panel's view, convener, on. I mean, we get a lot of evidence, and most people would imagine they're a special case. In the previous session, which a lot of you heard, I think we would all agree there was compelling issues around domestic violence. I wonder, given the wider implications of health and safety, and as has been said that it's more than the individual, it has wider implications, would you favour a presumption in favour of council being sanctioned and in health and safety cases?
I've made very clear my position that should be the case, and would point to the fact that personal injury is already dealt with under special rules, and that's for good reason. And we believe that in the next period that there will be no such thing as a straightforward and simple workplace personal injury case as a consequence of the changes that we've seen. So we would certainly, for all cases above £5,000 that are held in the personal injury sheriff court, we would favour automatic counsel. Yeah.
Yes, I would disagree with that on the basis that if the employer is already saying that they're liable and the insurers have spoken to the employer and they're admitting that they're liability pre-litigation, then there's no reason for the automatic presumption to counsel.
Would you like to rebut that, Mr Moxon?
Well, I presume that one would have already gone through various pre-action protocols, but there'll still be a range of issues around levels of compensation and other issues that we would need assistance with.
There's an issue with we don't have compulsory pre-action protocols yet in Scotland, but I know the Scottish Civil Justice Council are looking at that as an issue just now, and that would hopefully feed into the new Sheriff Personal Injury Court system.
Right, I was going to ask about that, but I don't want to extend. Perhaps you'll let us know later what a pre-action protocol is. Well, perhaps you could tell us right now what you're talking about.
Yes, it's just a series of steps for both of the parties so that the issues are narrowed before the case is litigated.
Right, narrowing the dispute.
Yes.
John, you happy?
Yes.
Right, and I'm going to move on to Margaret, then Christian. Please, Margaret.
If I could return to the Sheriff Appeal Court, the Gill Review recommended 3 judges. The bill allows for 1 judge to sit. This could be a Sheriff Principal or it could be a Sheriff for 5 years standing. Lord Gill, I think, had some real reservations about a Sheriff for 5 years standing hearing an appeal on the decision of a colleague, and was very much of the view that it shouldn't be the same hierarchy hearing appeals. Could I have your view on that?
Yes.
Well, I think, Ms Mitchell, I've already made my view plain. This is really not at all satisfactory. To try to dress this up as an improvement in the civil justice system is an Orwellian use of language, quite frankly. I noticed in the civil, when I was looking again at the civil court review, that Lord Gill said that the 3 Sheriff Principal appeal court model could be achieved with negligible expense. And it seems to me incomprehensible as to why that has been departed from.
Just to develop a little bit the point you made about the development of law, because we are in a situation under the Bill's provision as they stand, where under Section 47, the application or interpretation of law can be binding on a Sheriff and Justice of the Peace, and that can be decided by a Sheriff of only 5 years standing,
yes,
as opposed to going to the court session with all the reasons. So yes, obviously that would be a cause for concern.
Indeed. It's a diminution.
Or compounding it, which in
yes,
some way.
Yes.
Yeah. Anyone else on that one? Can I just, you've very clearly outlined the pressure on Sheriff Courts at present. If they do medical negligence cases, then the time frame involved in that could be just mind-boggling. Can I also ask if you're aware or you have concerns about Sheriff Court closures, how this will impact and compound on these concerns already expressed?
It's the synergy or the synchronicity, I'm not exactly sure which is correct, is the compounding effect I use the term train wreck, and I'm conscious that that is a slightly apocalyptic description.
Apocalyptic language all the time,
Indeed.
Mr. Conway. It's
Indeed.
quite entertaining.
I do not shrink from it. May I invite the members of this committee, go to your own local sheriff court and see the pressures on the courts there. They are operating under huge time constraints. I was amused, if I may say, Madam Chair, to see your exchange with the sheriffs when you suggested to them that there might be a meltdown if these proposals went ahead. Or you asked them if there might be a meltdown. If
You
these
did
cases...
it. I think it was Mr. Penton, and we're
Was
not
it Mr. Penton?
easily confused with each other. I think you must go to Specsavers.
As I recall, the sheriffs were not prepared to say that there was a meltdown. And with all due respect to them, they are not the persons who are being melted down with these proposals. Their workday, and can I say that, just in case I have to meet Sheriff Wood again, they're all hard-working. The sheriff court staff are extremely helpful. The agents do their best. We're soldiering on in a hopelessly antiquated system right now. The idea that this is going to be improved without funding, if there is no funding, seems to me to be basically deluded. So, just to get back to the point I was making, the persons who will be suffering are the people who have to turn up, have their cases adjourned on day one, get some kind of priority some 3 or 4 months down the line in day 2, and then watch as it bounces about the sheriff court timetabling, subject always to the demands of, quite properly, crime, family cases involving children. It is not a proper judicial system for the 21st, or legal system for the 21st century.
I wish to comment on that. Mr. Milligan.
Simply to agree wholeheartedly, I suspect that there would be nobody on this panel who would disagree that personal injury work is not adequately dealt with in the sheriff courts as they currently stand. That's no criticism of those people in it. They simply don't have the economies of scale and they have more pressing requirements, particularly from criminal cases.
Margaret, have you anything else? Christian, last question.
Thank you very much. Good afternoon. Somebody touched on it. I think Mr. Rogerson touched on it, and I would like the other members of the panel to let us know what they view on it regarding the reintroducing of civil jury trials, which will not be a saving, I think, Mr. Conway.
Well, I'm in favour of civil jury trials because it brings, for want of a better expression, it brings the people directly into the court and into the quantification of damages. That it's not just me who says this, but the judiciary tend, over a period of time, to be out of touch with the value of money. One might...
Judiciary, you're living dangerously, Mr. Conway.
One might speculate as to the reasons for this, but the last Lord President, Lord Hamilton, said so in terms. And so every so often you get a kind of spike in damages to reflect this. The injection of the occasional jury trial. That Mr. Rogerson talks about jury trials for whiplash cases. There are no jury trials for whiplash cases. Very occasionally you get jury trials for things like fatalities. And the jury has to be told, so to speak, that there is a range above which they cannot go. So what you have just now is a kind of mixture of judicial involvement, which is quite proper, and then also from time to time the intervention of the jury, which keeps them honest.
You were going to committee, Mr. Rogerson, and dispute that, are you?
No, not necessarily dispute it, just clarify it slightly.
That sounds like a subtle way of disputing, but we'll find out.
No, in terms of what Ronnie says, yes, there should be jury trials and things like fatal damages awards, but there will be, because they'll be above the exclusive competence of the Sheriff Court. But where I have a problem is the proportionality idea and having jury trials on low-level personal injury cases. I think adding that complexity to something which the court should be looking at efficiently and quickly just is completely out of proportion.
Mr. Millican.
Yes, I must contest what Alan Rogerson says about fatal claims being above the privative jurisdiction. He and I have crossed swords in a number of fatal claims, many of which have not been worth $150,000, one of which went to the inner house, the five-judge decision in a case called Hamilton, which has set the benchmark for how juries are now given guidance. Now, that was a case in which the jury had awarded £90,000 for the loss of a son, and the court held that that was excessive, and the case ultimately settled for a lot less than that. And the most recent judicial pronouncement for a similar type of award was £42,000. So it's not true to say that fatal claims will always exceed the level, even if it's set at £50,000.
Thank you. And yes, Mr. Rogers, you want to come back in now?
Yes, just a final point on that one.
Now, the word final does mean final.
Yes, no, definitely.
Right.
Robert is right to say that not every fatal claim would be over the exclusive competence, but the cases in question, there were more family members which in total would have pushed it over the exclusive
I see,
competence.
so it's for multiple claimants?
Yes.
Okay. Rod, small one. No,
Point.
I'm not.
Yep, okay.
No, you can have it, but are you finished? Sorry, if you're not finished.
A small second one,
a small one, and then it's Roddy, and then it's final.
Thanks very much,
Right.
Governor. Just about what Mr. Moxham said earlier on regarding as different pursuers representing themselves. I know that all injury cases are often complex, but there are a lot of injury cases which will not be that complex. Do you recognize there will be a need maybe for, as a principle of access to justice, for people wanting to represent themselves in simple cases? And would you be reassured, which we talked about, the sheriff having a kind of mediation role?
Not really. I would hesitate to wish to deny anybody the opportunity to pursue a case in the way that they would. Would I advise it? Absolutely not, because I think that the cases, particularly obviously workplace cases, will be complicated and getting more complicated. So, in a sense, should they have the right is a question I'll leave to one side. Would I advise it? Absolutely not, and therefore it should not be. It should not be the presumption that the workplace personal injury cases are pursued in anything other than in the specialist court. I mean, could I also say, just on the previous point we were discussing in terms of access to counsel, it is our absolute experience that it often takes until counsel is actually instructed before we can get the insurance industry to actually come and settle. In our experience, at least 80% of cases require that to happen. So to say that we get to the stage that we can get to the stage of agreeing employer liability and then everything is hunky-dory before counsel is instructed doesn't tend to be our experience.
Mr. Corney.
Mr. Allard, we've tried that already. The old small claims system was precisely that system, unrepresented pursuers. But the problem which was encountered is, and this was the 1998 research which I've referred already, the problem which was encountered is that the academic writers talk about one-shotters, that's the people with only one brush with the legal system, and the repeat players, Mr. Rogerson et al. And the problem which was encountered is that the repeat players will always instruct lawyers. So that if I sue Scottish Water, for example, I am not going to get the in-house technical person from Scottish Water. They will instruct lawyers. So there will be no equality of arms. There will always be representation for the repeat defenders.
The new role of the sheriff in mediation, balancing that effect?
The problem, I appreciate the point was made earlier on that in the consumer cases, most of the time you're talking about a single issue. Was the suite defective? Was it delivered on time? Did it look like the catalogue? In almost all personal injury cases, it's much more difficult than that. Was there a duty of care? Is there a statute that refers to it? What do the previous authorities care? What medical evidence is required? It just doesn't fit. There's an academic once described it, let the forum fit the fuss. And
Sorry, I've got a dying, excuse me, I'm doing it myself, dying member of the committee to my left. I missed your last word. Let the forum
fit the fuss.
The fuss, yes, not the fleece. I wonder where a fleece get into this. Okay, right. Thank you. No, I think, excuse me, I think I've got, you're passing something around here. Last question, and definitely the last question, and the word final means that, Rod, please.
Mr Milligan, you say, or encompass in the submission, say costs of litigating personal injury cases in Scotland has been significantly lower than in England, though we're not aware of this having been translated into lower insurance premiums for Scots. What's the evidence for that, and what does Mr Rogerson and maybe others on the panel say to that?
I did read the various responses from, for example, the Association of British Insurers, and I looked in vain for a promise in the reduction in our premiums that we can expect once these reforms come in. And the simple answer is, of course, Scotland is a small country as part of a much larger jurisdiction insurance-wise. So a multinational insurance company is not going to make a significant reduction in premiums by saving some money in Scotland. And we have already seen that. In England, there has been a big... The litigation costs have been far higher. I do a lot of work for English insurers. The number of times I've been asked to give an assessment of what the costs will be, and I say what it will be, and they say, that seems very reasonable. What about the other side's costs? And I say, no, that's all in. Because, as Alan Rogerson will confirm, in England they have, up until now, had a system whereby the large success fees have been recoverable. In Scotland, they're paid out of the claimant's damages. And that has meant that costs have been much higher in England. It's recently been reduced to be more in line with Scotland. But there hasn't been any appreciable difference in the insurance premiums that you pay for your car insurance than somebody in a similar position in England would. And that's almost inevitable because, of course, you may cross the border and be injured in an accident in England subject to their rules.
Corroborate that, Mr Rogerson.
I'll be very careful what I say next. I think the difference, there is a danger in just looking across the border because England have the fixed fees for the low-level cases and the compulsory protocols that I was alluding to earlier on. So they already have this proportional step change in place for their cases. And it's right, to, as Mick Roberts says, the fees on the larger cases have been well out of proportion down south compared to up here. Our problem up here, and the data that we've collected and identified, is the disproportion that currently exists on the low-level cases, which of course there are more of. And that's the bit that we need to address in the court reform bill, and then hopefully the rest will follow. In terms of the ABI and the lower insurance premiums, I would certainly defer to them on that and look to them to see if we could get any comment.
Yes, thank you. I think you want to say something, Mr Conway. Is it wise to say anything else now you've offended the judiciary and the sheriffs? Well, have a go at the panel, have a go at the committee.
You will be shocked to hear, Madam Chair, I'm about to answer that. I do not know the answer to that question, Mr Campbell. Are premiums cheaper? But what I will say is this. I've already suggested the insurance industry will be big winners out of this. They have a further prize in sight, which is the low-value cases. The Taylor Review has already dealt with this issue. Sheriff Principal Taylor pointed out that there is this asymmetrical relationship. So it's one-shotters, repeat players, and that unless a reasonable level of expenses, of costs, is assimilated into low-value procedure, specifically cases under £5,000, claimants will be unrepresented. So, not satisfied with all the savings that the insurance industry will get out of sanction for counsel, Mr Rogerson is now hunting for an even bigger prize. I was deliberately... I was deliberately not going there.
You were provocative.
Madam Chair,
that
is exactly what he's doing.
Right, before you come back, Mr Rogerson, I'll have Mr Moxham in and perhaps it will... Yes.
Maybe Ellen Rogerson will contradict this, but we're not aware of any reductions in premiums down south that have taken place as a consequence of the outcome of the Jackson Review and the various attempts to limit costs. I think we were promised that we would, but I don't think we've seen any yet.
Pretty friendless now, but we'll come to the last one.
I know. I'm not going home to get my deer stalker quite yet either. Just to come back on what Ronnie said there in terms of the low-level cases.
It's Ronnie. I'm so glad we're ending on that kind of note, yes.
I'm trying to attract friends. It's not happening, but I'm trying. On the low-level cases in Taylor's review and expenses, one of the recommendations was a one-way qualified cost shifting, so that there is no cost to the pursuer in pursuing these small actions as well. And insurers welcome that and just want it balanced out with the compulsory pre-action protocol element, so that there's not as many cases going to litigation just because the parties can't agree, and narrowing the issues.
See reduced premiums. I'm just going. I hope this is going to be kind words, Mr Willikin.
Finish on a friendly note all round and point out that actually the insurance industry is not some ogre. It's essential to this whole process, and generally it is very well run. But inevitably, of course, it's a commercial organisation, and it has to take such benefits as it can.
On that note, which I think was neutral, I'll finish this evidence session. Thank you all very much. Thank you indeed. And it's concluded. Thank you. I'll give them a second to move. I had to go to the sheriffs. I had to go to the judges. I thought it was quite entertaining. Go in front of them again. I don't think Mr Conway actually is a solicitor, and appears he seems to be managing the solicitors. I just thought if he goes in front of them, we're just going to get... So I'm not able to decide this. Right. Now, I'm just going to move on very quickly, so don't leave your seats. We come to private session shortly. Item 3. Moving on. We have we have 5 negative instruments. The first 3 instruments are the Fireman's Pension Scheme Amendment Scotland Order 2014, SSI 2014/59, the Firefighters Pension Scheme Scotland Amendment Order 2014, SSI 2014/60, the Police Pensions Contributions Amendment Scotland Regulations 2014, SSI 2014/62. The purpose of these first 3 instruments is to increase members' contribution rates in public service pension schemes in accordance with the 2010 UK Spending Review. The instruments come into force on the 1st of April. The Delegated Powers and Law Reform Committee is content with all these instruments. Do you have any comments in relation to those 3 instruments?
I won't object to them, but I have to, because it would be a futile exercise, but it's deeply depressing that the Scottish Government was precluded from doing anything due to the intervention of the Cabinet Secretary. Due to the Secretary for the Treasury, Danny Alexander, with a threat to remove monies. I think this is an attack on public sector workers which isn't merited.
Sandra?
Basically reiterate what John Finney had said. They will take £50 million out of our budget, basically, and it's an absolute disgrace.
To say, I think when we were speaking to the police, one of the main concerns was their pensions, what was happening to their pensions, which is UK legislation. Let's go on. The 4th instrument is the Police Service of Scotland Performance Regulations 2014, SSI 2014/67. The purpose of the instrument is to introduce a new definition of unsatisfactory performance as, quotes, an inability or failure of the constable to perform the duties of the constable's role or rank, brackets, or both brackets, to a satisfactory standard, close quotes. This instrument also comes into force the 1st of April this year. The Delegated Powers and Law Reform Committee is content with the instrument. Do you have any comments to make in relation to the instrument? Oh, sorry, Alison.
It's okay. I had some concerns that these proposals change who can hear the appeal now. It says an appeal can now be heard by a senior officer rather than the chief constable, which is what the current 2013 regulations allow for. And it would have been useful to understand just quite what the representations have been made from the unions about that.
It's coming into force Monday.
Yeah.
So I think there's virtually procedural terms. If you want to do anything, nothing we can do, but your remarks are on the record. Are members content to make no recommendation in relation to this instrument? Thank you. The fifth instrument is the Police Service of Scotland Conduct Regulations 2014, SSI 2014/68. The purpose of the instrument is to introduce procedures which are more akin to modern employment practice and take into account ACAS principles. The regulations set out the standards of professional behaviour that constables should maintain during their service. It comes into force on the 1st of April. That's Monday, is it? Tuesday. The Delegated Powers and Law Reform Committee agreed to draw the instrument to the attention of Parliament for two reasons. Firstly, on the ground that the form or meaning of the instrument could be clearer, Regulation 7 provides that a constable may be legally represented in any misconduct hearing or appeal hearing. However, the effect of Regulation 25(8)b is that legal representation at an appeal hearing is subject to the discretion of the person determining the appeal and may as such be refused in cases other than those where disciplinary action constituting demolition in rank or dismissal has been ordered. I'll come to the other ones and I'll let you comment after that. Secondly, the DPLR committee agreed to draw regulations 15 and 16 the attention of the committee, suggesting we wish to consider whether the exercise of the right of a constable to object to the appointment of an assessor, a solicitor or an advocate to advise at misconduct proceedings could be frustrated by the fact that the appointment of such persons is not a matter in which the constable is required to be given notice in the misconduct form. Comments? John?
Strange though it may seem, that's actually an enhancement of conditions. Yes, well...
That seems to me to be diminishing the...
Well, previously, it was the top three options, so dismissal, requirement to resign or reduction in rank, entitled an officer of the Federated Ranks to be legally represented. You weren't entitled to be legally represented before. There is an entitlement now with things like the very low reprimand, caution, fine or increment. So that's an addition rather than a reduction.
It didn't seem that to me, but you assure us that this is better.
Well, that's certainly my reading of it. And as with the other issues, I think we could rest assured that if there had been any issues, we would all have been lobbied very strongly on it.
Yes, thank you for that. So you're content to make no recommendation in relation to this instrument. Is that correct? Thank you. We now move into private session.